Thank you, Your Honor. The state would submit to the court that there has been sufficient evidence to show probable cause that a crime was committed and that Jenna Holm was one who committed that crime. Going specifically, count one is involuntary manslaughter. The state has proven or shown based on the evidence that there's probable cause that on May 18th, 2020, in Bonneville County, the state of Idaho, through evidence that was received from various witnesses, Jenna Holm, who was identified, was the person who was running down the middle of the street, failing to comply with officers' orders, acting unlawfully in that regard, had a machete, raised it at Deputy Mazer as she charged toward him, acting unlawfully in that regard, continuing to act unlawfully when she struck Mr. Butter's truck, as well as continuing to fail to comply with the requirements that the law enforcement officers put on her through their orders and commands that they were giving to her. And that in that unlawful act of remaining in the street, continuing to be a danger to others, and not complying with law enforcement orders, she produced the death of Deputy Wyatt Mazer. Her actions required the officers to continue to address the situation, which they did. She remained in the middle of the road, which required them to address that situation in the road. As to the aggravated assault, the state has shown that on May 18th, 2020, in the state of Idaho, Bonneville County, Jenna Holm again was identified as being the person who committed assault on Deputy Mazer when she raised the machete and ran at him. The state is not indicating that she was aware he was a law enforcement officer. This aggravated assault is for a regular civilian, but when she did so, it was when she charged Deputy Mazer, raising the machete above her head, as was seen clearly on the video, and that she committed that assault with a deadly weapon. Testimony has been clear that a machete is a deadly weapon, could cause death, and for those reasons, the state believes that evidence has been sufficient to provide probable cause that Jenna Holm committed these crimes, and that's the court bind her over.
Thank you. Mr. Wixom or Mr. Crane?
Thank you, Your Honor. Judge, I want to start my response by recognizing what a sad situation this entire thing is. I certainly couldn't even begin to speak to what a tragedy is for Deputy Major Widow. It certainly has to be a tragedy for Deputy Flagel, no matter what you find or any court finds. And for Deputy Botcha. Your Honor, I praise much of what Deputy Botcher did in this. My hat's off to him. In these kinds of volatile situations, I think on many points, not all, many, he did a great job. Having said that, I only have 2 minutes. Judge, I don't think the state has even approached substantial evidence for you to find that Jenna Holm caused a manslaughter. For a number of reasons. The first is they simply have not given you sufficient evidence that she committed an assault. Now I'm certain that they're wanting the court to consider, recall, perhaps even review the video from Deputy Major body cam. I hope that this, Your Honor, does, if this is taken under advisement. I'm sure the court has considered it already, if not. But if the court hasn't, then let's go back and look at the video. On Major's body cam, 5 minutes and 2 seconds. That's the alleged assault point. You know from the evidence, from testimony, and from that video, she's already been running. She's on the opposite side of the road, and you can see that from the video. She's not on the same side of the road that Deputy Mazer is. She's running towards the other truck. She's charged, the foundation for manslaughter, the charge is assault against Deputy Mazer. When she's coming down, you can see through Deputy Botcher's camera the extremely bright lights that Deputy Flagel has. The testimony is there's a special kind of dark out there. She's running. She gets down there, and as she's got the machete to her hand, she gets down there for less than a second. She raises it while the light's still in her eyes. She sees the car. As soon as she passes, it drops, and what does she say? I can't see. And she walks right by Major. Doesn't approach him, walks right by him. Now, remember, Your Honor, they talk about meth. I wouldn't downplay how bad meth is. I'm not trying to here. But they want the court to focus on that to show that Jen's just a bad person. So let's blame her. Well, Judge, that's a factor that Jen also considered a lot of mental health issues that were going on. She also, let's leave both of those things aside. Consider her state of mind, her intent. She's a lone woman on a dark, remote highway who just had her car rolled. She does not have cell service. Are we really gonna fault her if my wife in that situation, and there's a machete there, out on a highway where homeless people were just told to leave by Deputy Botcher? There's a lot of joggers and people around. I would say she gets to tap that machete until she gets to safety. So they want to fault her for having a machete in her hand. And then as this progresses, it's windy, it's dark. She's hearing Deputy Botcher give her commands. I'm not saying he did anything appropriate at all in that. But she's hearing that wind, the strange person's in front of her with a truck, who has a dog. He admits he threatens her with the dog. I understand as these commands from Botcher come, they come very quickly. Sometimes it's a sir, sometimes it's not. Go forward, keep moving, Jenna, stop. This is Deputy Botcher. Keep moving, go forward, sir. Not all the commands were there. There was wind blowing. We heard from the testimony, I got a transcript from Deputy Botcher. We heard from the testimony that it was very windy and he thinks that she could hear him. But we can't be sure of that. And considering that, well, I'll withdraw that point. In any event, Judge, we heard Deputy Cox, Trooper Cox explain that people go through shock when they go to these events. There's an element of shock here for Jenna and for trauma. Coupled with whatever mental health, well, I know the mess already there. It's not my burden to show that wasn't the case. It's the state's burden to convince you a lower standard of evidence is probable cause. They don't have to prove beyond a reasonable doubt. But it's their burden to get to cause. You can't find her over on manslaughter unless it was cause. It's their burden to show you that whatever that assault was, there was actually a threat made. I would argue, looking at the video, considering the evidence, less than 1 second, the immediately dropping it when she gets to the light. She's already had strange car stop. She's been dealing with this dog. But she didn't have an intent to threaten. That was an offensive move, and she was already running that direction, but on the other side of the road. That is not, more likely than not, that she committed a crime. It's highly suspicious of that facts, but it's not probable cause. She didn't commit an assault. Very quickly out, last thing. One thing that has not been answered here with respect to Sergeant Flagel, when should anybody, let alone an officer, drive through blinding lights? And then when should they do it at 91 miles an hour? Please look at the video, Your Honor. On Deputy Botcher's video at 5:50, you can see how fast Flagel's car was moving. Likewise, Judge, if you look at 5:29:05 in the exhibit, he's going 91. If you look at the video on Flagel's dash cam, at 5:29:10, there's no change. At 5:29:11, light brakes are applied. 10 seconds later is when Razor is killed. So 10 seconds, he chooses to drive through blinding lights, starting at 91. He's still above the speed limit at impact. The car in front of him came to a complete stop. He had been radioed and told before that someone was going to be stopping traffic. He already, with the radio traffic, the code 4 call, he knew there was a volatile situation. That is not the due caution that an officer always has to use. There's not one statute in Idaho, not one statute, that gives an officer the right to not use due caution. When it's dark, when there are blinding lights, when you know the situation is volatile, you may get there fast, and I get it. Cops need to respond fast. If I call them, I want them to come quick to my house, but I still want them to be reasonable. If you're on a relief court today and accidentally go 1 mile over the speed limit and got pulled over for speeding, and that officer in broad daylight gets smacked and killed by a drunk driver, under this theory, they can charge you, even though the drunk driver was the one who was at fault. Now, Wyatt wasn't drunk, but he was not using due caution. Nobody who's driven an Idaho through blinding snowstorms drives 91. Most of us, if we don't stop, would slow way down. Why couldn't he have slowed down 10 seconds earlier? And why didn't he? So, Your Honor, I think those questions leave him as a potential cause. And last thing I'm done. In Idaho law, there's a jury instruction for an accident or an explosion. I believe that, at best, but the court can find this was nothing more than a horrible accident, a tragic accident. The state hasn't shown you otherwise. And even if they want to point to Jenna for any judgment she should have had, or tragedy that could have been caused on the highway, absolutely sober, mentally clear Sergeant Flagel, trained and experienced, who'd have a radio of a dangerous situation, who knew someone was stopping, who chose to drive 91 through blinding lights. Certainly, he should have foreseen that. The causation factor, he's the actual and direct cause. I've given you a very short brief of legal authority. The state treats this as if it's a but-for argument. It simply is not. But-for is a rule out. In other words, it can't be said that but-for Jenna or Flagel were involved, then there is no causation for this. But if it can be, then you go to the next step. We assign proximate cause. We go through and we look at, was there autonomy in the actor? Was there wrong conduct? There are factors I've given you from Idaho courts. You look, could she have foreseen that he would break the law? He drive 91 and drive blinding lights? It doesn't be common sense to know that's a violation of Idaho law. You have an Idaho statute. It's probably reckless in anything, right? As well. She can't anticipate that a law enforcement officer is going to break the law. So, Your Honor, with that, I think this is horrible. I think it's sad. It's an accident. Jenna can be accountable for anything else she did. She needs to be accountable for. She didn't cause that death. Not under any fair-minded, I would argue, proximate consequences. That's all.
Your Honor, Mr. Russell will be taking, Mr. Spencer, excuse me, will be taking a rebuttal.
It's like Chekhov's gun. I think we still have about 8.5 minutes left. Mr. Garvin was much briefer than Counsel Wixom. Mr. Wixom talks about how you couldn't see that the law enforcement officer was going to be breaking the law. I'll ask the court to look at Idaho Code, section 49623. That is the law that says when responding to an emergency, officers can exceed the posted speed limit. He's not breaking the law. Mr. Wixom says he's driving through blinding lights at 91 miles per hour. First, this is not true. Exhibits have been admitted. You can see that in several of the different exhibits. He is driving that fast as he approaches. When he gets to the blinding lights as he's approaching them, that's when the brakes are coming on. There aren't any skid marks in this case. Trooper Cox pointed that out. What's that indicative of? We all know. It means he didn't slam on his brakes. He was already slowing down when he approached that truck with the high beams. That's why he's only going 53. He talks about how the car in front of him came to a complete stop. We've all watched the video. That happens after he gets past those blinding lights and realizes there's other people in the road, because that's the thing people don't foresee. We also go through, he talks about a jury instruction for accident, doesn't cite it, doesn't appear to be applicable in the criminal jury instructions. He talks about his brief of legal authority, not question the legal authority. In his legal authority, he talks about how clearly aggravated assault is a specific intent crime. Your Honor, the state would cite the court to State v. Bonaparte, 114 Idaho 577. This is the Court of Appeals opinion from 1988. Specifically says aggravated assault is a general intent crime and not a specific intent crime. And in case he thinks that's somehow been abrogated, I look at State v. Dudley, 2002 opinion from the same court, 137 Idaho 888. In fact, there is no need to show specific intent when proving an aggravated assault under either theory. He talks about Thompson v. State in that legal brief with authorities. I would note for the court's benefit, I happen to be intimately involved with the Thompson case. I was the attorney who argued it and prevailed. I think I might have a better idea of what Thompson stood for than counsel, who appears to be lifting passages from the losing party's brief in his description of that case. I would invite the court to read it. It's at 164 Idaho 821. The main issues here, they want to talk about mental health. Idaho Code 18207 does not allow that. to be considered in this case, absent admission of expert evidence on this issue, to consider it for state of mind. They didn't present any expert evidence. Mental health is out completely. What is in, however, is Idaho Code 18116. Intoxication is no excuse for a crime. A person who is in an intoxicated condition is criminally responsible for his conduct, and an intoxicated condition is not a defense to any offense. Defense to any offense is fine. And may not be taken into consideration in determining the existence of a mental state, which is an element of the offense, unless the defendant proves that they didn't know that it was an intoxicating substance when he consumed, smoked, sniffed, injected, or otherwise ingested the substance causing the condition. Evidence here is very clear. Jenna Holmes injected a substance. She believed it was meth, which is an intoxicating substance. She drove up on Bone Road. She flipped herself into a ditch. She left the scene of that accident. She walked down the road wielding a machete. Deputy Botcher asked her to stop, asked her to get out of the road, asked her to put down the machete, asked her repeatedly, and she would not comply. She stayed in the road. Counsel Wixom says that when you watch the video, she's running down the road, she's not even going after Major. I disagree with that. I have seen the video many times. And she's heading directly for Major, who jumps back in obvious alarm and draws his weapon. Jenna Holmes committed an aggravated assault. That's an aggravated assault. She threatened him by deed, by act, that she was going to, with a deadly weapon, cause some bodily harm on him. He perceived that threat. She had the immediate apparent ability to follow through with that threat with the machete raised above her head. He took action consistent with his alarm and fear from that threat. This is an aggravated assault textbook. Jenna Holmes broke the law. She broke the law again and again and again. I cannot think of anything she did that evening that was not a criminal offense. And those criminal offenses...
Objection, Your Honor. They've charged her. The hook they're trying to get through is that aggravated assault. He's going to get into other crimes. He needs to read his complaint.
We have two crimes, and that's what we're dealing with.
Thank you. But that crime, the predicate is the aggravated assault allegation. He's going to start bringing in leaving the scene as a predicate. I'm going to object.
And I agree with that. Your time's up, counsel.
May I please read the complaint thing, Your Honor?
I got the complaint from you, counsel. I'm well aware of what it says.
The perpetration or attempted perpetration of an unlawful act.
Continue reading.
That's the end. 10 years, $10,000 fine, $5,000 compensatory fine, restitution.
You're going to rely on that as adequate notice.
That's the complaint you
All
filed.
right.
That's the complaint that's been filed. Thank you, counsel.
Thank you, Your Honor.
I start with indicating that there is no evidence of mental health issues for the court at this time, so I'm not going to consider anything in that regard. And I would also indicate that during the course of this hearing, there have been a lot of information that may or may not be very helpful or admissible in a trial, but we don't have the same standard of proof at this level that we do at a trial. This is probable cause, and to determine whether or not there's probable cause to believe that the offenses were committed by Jenna Holm, as indicated in the criminal complaint. I want to go first to the aggravated assault with a deadly weapon, which is count 2. I find specifically that there is probable cause to believe that she has committed that offense. I'm not going to go into a great deal of detail because I think that's for trial, and I don't want anything that I say that would taint trial evidence or lead anybody in a certain direction, except to say that she had a machete. I believe she wielded it in a very unsafe manner, a very dangerous instrument raised over her head, creating a well-founded fear in Deputy Wyatt Major. I find that to be find that there's probable cause for that. Then I go, and so in count number 2, I find there's probable cause. By the way, I want to just indicate also, Mr. Wixom filed excellent points and authorities, and they were responded to by Mr. Garvin. I've read those. I'm very familiar with the law. I'm very familiar with the arguments that are being made on both sides. So I find that there is a probable cause to believe that she's committed the offense of aggravated assault. I also find that there's probable cause to believe that she has committed the offense of involuntary manslaughter, which is the perpetration of an attempt or perpetration of or attempt to perpetrate any unlawful act, or in the commission of a lawful act which might produce death in an unlawful manner or without due causation and circumspection, or in the operation of a firearm or a deadly weapon in a reckless, careless, or negligent manner which produces death. I find that there is probable cause to believe that she committed the offense of involuntary manslaughter as charged. So both of the charges, she's been bound over on both of those charges at this time. She's got a $100,000 bond. I would indicate that the next hearing for Ms. Holm is a hearing in front of Judge Dane Watkins for the next stage of these proceedings on March 9th at 10 a.m. So she's being bound over with the bond, and I would commend the attorneys for their vigorous and zealous advocacy of these points and the way things have been presented today, but the court finds without anything further that probable cause would shown for both of this. That's the order of the court. She's bound over. We're off the record.
All right.